time, and then I'm going to allow a response. The answer is either going to be yes or no, and the answer to that question will determine whether or not you're involved in this hearing or not. But I don't allow ridiculous comments to be made, and I don't allow litigants to control the method of this court proceeding. Instead, I ask simple identifying questions because I've just called a case, and the case is called Katrina Thompson versus David Thompson. If the answer to the question I'm about to ask is yes, you're going to be entitled to proceed and be heard in this case. If the answer to the question I'm about to answer is no, you're not associated with this case and you won't be able to be heard. So the answer to the question is, are you David Glenn Thompson?
I am that living soul allowed to use that? Yes, I am that soul.
Mr. Thompson, it's either a yes or no, or you're not going to be involved in the hearing. Let me take it a step further and let you know what happens if you are not David Glenn Thompson. My next question will be, is there any other David Glenn Thompson in the courtroom or otherwise? If I hear the answer to that question, no, it's likely that the court will issue a bench warrant for non-appearance. So it's your last chance to tell me.
Sure. Yep. Yes.
Are you David?
I feel really coerced right now. Thank you. I appreciate that.
Are you David Glenn Thompson?
I believe I just answered that with a yes, and I feel really coerced right now.
Mr. Thompson, I'm not going to allow ridiculousness to control the day in this court proceeding. I don't view this office as needing to allow that, and the law doesn't view this office as needing to allow it. I have a simple and straightforward job to proceed with. If you make that job difficult or impossible, I'm going to simply remove you from the hearing because I don't need to hear ridiculous commentary from you. So when I ask you if your name is what you're listed as on this docket and you tell me you feel coerced, I respond by indicating this. You can participate in this hearing if you're reasonable. If you're not reasonable, I'm going to remove you from the hearing. Am I clear?
Well, I do apologize. You're very clear. I'm just trying to correct errors upon your record.
This record, again, Mr. Thompson, is clear, and it will be more clear if you let me proceed further past what should be fairly innocuous, which is whether or not you're a named party. Now that we've gotten past that rather innocuous, fairly clear point, the next really clear point is this. You're here today, Mr. Thompson, because there's an allegation that you've not been paid to support as ordered by the court. If you're found to have not been making reasonable payments out of your available income, the court could hold you in contempt, and contempt is punishable by potential jail. In this case, we're also here to address a bond that you had previously posted. So when you posted a bond, I ordered that a hearing would be set today. When I set that hearing, it's to address several things. Number one is to address the issue of contempt and whether or not I should forfeit the bond that you previously posted. The order specifically indicated to you why we're here, but because there appears to be difficulty in you understanding that, I'm going to go through it. Defendant is required under the terms of that written order that you got a copy of to show cause why you should not be held in contempt for failure to comply with the court's order. If you fail to appear, you can be found in contempt and a bench warrant can be issued. If contempt is found, the court can apply any enforcement remedy allowed under the law. The bench warrant is discharged. So again, that's the requirement of the prior order. It enunciated clearly that you were going to appear here on December 5th, and I'm glad that you're present to be able to address those issues. So Ms. Spillane, let's start with the bond. From the friend of the court standpoint, are you asking the bond to be applied towards any outstanding arrearages?
Yes, sir, we are.
Mr. Thompson, did you hear the suggestion by the friend of the court?
I did, and unfortunately, I did not put the bond up. A friend of mine put that up. I'd prefer it go back to them.
Well, the bond is required by statute, Mr. Thompson, and the reason it's required is because when you have outstanding arrears, the law says that if I issue a failure to appear bench warrant, as I did in this case, that I have a statutory duty to impose a bond in the amount of 25% of the outstanding arrears or higher based on my determination. So the amount of the bond that was posted on your behalf is going to be ordered to be forfeited towards the outstanding fines and outstanding child support arrearage. I understand your request, but I'm also confident that the person who posted bond in this child support related matter is, or should be aware of the fact that when posted, it couldn't be utilized for those purposes. So I note your objection, but I rule otherwise in order that the bond that was posted will be forfeited towards the ongoing support obligation and or any arrearages. Once that's done, Ms. Spillane, can you tell me in general, what is the outstanding arrears if there are any, and what is the outstanding monthly support obligation?
Your Honor, this is an arrears only case. Once that bond payment is credited to his account, the total balance would be $14,833.05.
And does friend of the court have any suggestion on what we should do outside of having the bond forfeited as I've ordered already?
We would like to refer the defendant to the referee to monitor payments going forward.
Mr. Thompson, did you wish to be heard on that suggestion by the friend of the court?
I don't even know what to say. I don't really feel that it matters what I say. You just do what you want. So, I mean, I'm looking at court orders in front of me. I'm looking at House Resolution number 10 saying, you know, you can't ask for money because of the bankruptcy. I don't even believe this is an actual Article 3 court. But hey, here we are. And I'd like to know what happened to the promissory note that was sent in 2017 for $20,000 gold equivalent. Registered mail to Clerk Divider, I think it is. And why that wasn't credited to the account, since that would be a securities under these laws here.
So the court would note that I've exercised my discretion to mute Mr. Thompson. I'm going to do my best to explain why. This court proceeding has started difficult. It appears to be proceeding difficult, but it's really not a difficult understanding or case to understand in terms of the background. The background is that years ago, this case was instituted. It's a 2017 case number. It was instituted as a support matter. As the Ms. Blaine just indicated, this is a support arrears only matter, which means there's no longer any support that's currently charging, but there are outstanding arrears. Arrears means, of course, that there was a prior court order, and that court order was for Mr. Thompson to pay support. Mr. Thompson either did challenge that and was found not to have a legal challenge to that amount, or he didn't challenge it. And either way, the amounts have been, for years, been determined to have been owed. The amounts have not been paid, however. And even after this $5,600 bond has now been forfeited, the total of arrears are $14,833.05. That's not an insignificant amount. When pressed on that issue or questioned if he wanted to be heard, rather than be heard on what the friend of the court issued, which is a fairly, I would say, insignificant request to have the payments going forward monitored through a referee process, Mr. Thompson chose instead to bring up things that have nothing to do with this case. For example, I think, rather oddball claim that this is not an Article 3 court, or things referencing a surety contract, or other words that, although they seem quasi-legal, don't bear any particular relation to this case. And so the court is left with the suggestion of the friend of the court on what appears to be a fairly innocuous arrears-only matter, and I keep saying fairly innocuous to the court. This is not a difficult factual determination. It's not a difficult legal determination. An order was apparently in place. It ordered Mr. Thompson to pay. He's not done so. Arrears are in the nature of almost $15,000 after the bond was applied, and yet there's claims about promissory notes, and other words that I've heard but don't understand how they have any relationship to this case. And I'm quite confident on the record that's been made so far, if I allowed Mr. Thompson to be heard further, I would become more confused, not less. And so it's important for me to note that every opportunity is given to litigants to be heard. Those limitations, some limitations on that right to be heard, are present in this case, and that is, I allow litigants to be heard if it's responsive to the question set forth. If it's not responsive or relevant to the question set forth, I don't find it helpful. And I wouldn't find it helpful if the friend of the court offered things that weren't relevant to the issues at hand either. So again, the court has exercised its discretion to bar any further oral argument by Mr. Thompson. Instead, I'm going to follow the suggestion of the friend of the court. I'm going to refer this case to the referee docket for continued maintaining and watching over whether or not these payments are made going forward. I will, of course, maintain jurisdiction over this court, over this case. I'm simply referring this case to the referee for further proceedings, and I'll also sign that order once it's presented by the friend of the court, ordering that the bond that was posted on Mr. Thompson's behalf is forfeited towards the outstanding arrears only in this matter. Do you have any questions, Ms. Blaine, on this case?
No, sir.
All right, thank you. The court is in recess on this matter then.
Well,
now calling the matter of the people versus Cinnamon Woodford. This is ticket number P12172275. Count 1, no plate on a trailer. Count 2, no insurance misdemeanor. Count 3, drive while license suspended. Appearance for the record, starting with, I don't think counsel is represented in this matter. So Ms. Woodford, state your name for the record, please.
I'm here by special appearance, by coactives,
And what's your name?
Cinnamon,
Last name too?
Woodford.
All right, ma'am. Now, you know you have the right to have an attorney in this particular matter. This is a misdemeanor matter. And by right, under law, you have the right to have a representative in the form of an attorney for this particular matter. Would you like to have an attorney in this matter?
I do not consent to these proceedings. The offer is not accepted. I do not consent to being surety of this case and proceedings. I demand the bond be brought forth immediately so I can see who will indemnify me if I'm damaged.
Okay, so the question that I asked is that, did you want to have an attorney provided for you in this particular matter, Ms. Workford?
I do not consent to these proceedings. The offer is not accepted. I do not consent to being surety of this case and proceedings. I demand the bond be immediately brought forth so I can see who will indemnify me if I'm damaged.
Okay, Ms. Workford, you're quoting from civil, well, not even civil procedure. Right now, you're quoting from the UCC. This is a criminal/traffic matter. So those proceedings govern these type of cases and these type of matters.
What crime did I
Now,
commit?
Ms. Workford, if you do not wish to participate, then what ends up happening is that this matter will go into a show cause. After the show cause, then it will enter into what's called a bench warrant for your arrest until you handle this matter, at least the misdemeanors, and these are all misdemeanor offenses. So that's how this is handled on this particular end and this particular point. The offenses that have been alleged at this point in time is that there were no plates on your trailer, that there was no insurance on a Chevy vehicle, that's a 2007 Chevy vehicle, and that the driver's license was suspended that you had. And so those are the offenses that have been alleged at this point in time. Right now, they are just allegations. So you have the right to have an attorney, which I don't know if you would like to have that right or not. You have the right to have a jury trial. You have the right to have a bench trial. A jury trial is a trial before 6 people of the community in the city of Detroit who come and they will hear the facts, and based on the evidence and based on the law will make a decision. A bench trial is the same thing, only a judge, being myself, would sit there and I would hear those same facts and evidence and apply the same law in the same way. You also have the right to plead to these matters. There can be an officer.
I'm not here to plead, ma'am.
Ms. Warford, these are your choices. So it's up to you. It's a decision that you have to make. It's not gonna go away, okay? Just because you want it to go away, it's not gonna go away. There is jurisdiction for it. So it's your decision on today. If you don't wanna participate, then it's going to go into show cause because you can keep coming and it's just gonna hang out there. But eventually we're gonna have to adjudicate this matter at some point in time because it cannot remain on this docket indefinitely. So you have to make some decisions as to what you would like to do with these matters.
Well, I still do not consent to these proceedings.
Okay. So if you do not want to participate, I'm going to be forced to put it into what's called a warrant. You have to participate. So you have to come in and ready to go with something. I know you may not like it, but as a person who is a citizen of the United States of America, who is a person who lives in Michigan and is utilizing the services of our world and our community, these are the things that have been alleged. Now, if you're saying that the officer wasn't, correct in those or something, your license was valid or you had car insurance and you can present all of that, then we can try and figure out if we can get a new offer or something different. But other than that, you do have to stand for these particular allegations that have been made at this point in time.
Well, I never had a driver's license, so I still don't consent to any of these proceedings. So, I mean, I still don't consent to these proceedings. The offer is not accepted. So,
Ma'am, you can stop reading that. I know they've given you a line cue that you are able to read off of. But this is, as long as you utilize the services of everything in the city of Detroit and you fail to do those things, this is the ticket that proceeds. But I don't know that you failed. You said you don't have a license. But did you have car insurance at that time that you can present?
no.
Was it a trailer on the back of the vehicle?
Judge, I'm
Yes.
sorry. I know I'm not on this case, but if I could file an amicus brief of sort. Judge, I'm a little uneasy with, this is Matthew Dupree, P80132. I'm a little uneasy with the questioning here, just because technically if this matter were set for trial, what she says here could be used against her. And so I'm not sure she should necessarily be answering those
You
questions.
want your representation, Mr. Dupree?
She did not, Judge.
Did you ask her if she wanted your representation?
I did, Your Honor.
Did the court ask her if she wanted her representation?
You did, Your Honor.
You can continue to talk, Mr. Dupree. I appreciate you stepping in on her behalf.
I appreciate that, Judge. Your Honor, I'm just I just thought I would make that representation. I don't think the city attorney would actually pull the transcripts, but it is worth noting that anything she said here, could come back. So it might, I'm not sure that necessarily that questioning would be appropriate. Sorry, Judge. Thank you.
You're welcome. Thank you, Mr. Dupree. I appreciate you coming in to step to the rescue of Ms. Woodard so that she understands.
It's Woodford.
Woodford, sorry, ma'am, Ms. Woodford. Ms. Woodford? We have to make a decision, so how do you want to move forward with this?
Well, I'm not here to plead because I'm
Okay.
not here
Would
to
you like
plead.
a bench or a jury trial?
Are you making that determination for me, ma'am?
You have to have a bench or a jury trial. You told me you don't want to plead, that's fine. You probably should have a jury trial then. And I don't have any jury trials for this year.
Are you
So,
making that determination for me, ma'am?
if you don't make the determination, yes, the court is making the determination for you. Yes, because I have to move it. I have to move it. So it's either, Attorney Dupree, can I have a bench trial now? I don't want to violate anything.
No, Judge, she has to explicitly waive her right to a jury trial, and strictly speaking, she has to do it in writing. So I would say if she's saying she will not plead, that would be standing mute, and I think the court would have to set it for a jury trial.
Okay, that's fine. All right. So I'm gonna have to set this for a jury trial. I think she phoned me. Huh? Oh, this is- thank you.
And Judge, she logged off.
She was frozen, so it may just be her system. I'm gonna give her a second to sign back on. If she doesn't sign back on, I'll just put her on warrant status. But if she signs back on, I'm gonna try and give her at least a jury trial either.
Thank you, Judge.
Sorry about that. I had a very bad power surge.
I figured as much. So no, back on the record, I figured that it happened because you kind of froze up and my clerk informed me that you froze completely. So I.
Okay. Okay, thank you.
You're welcome. Okay. So I'm setting this for a jury trial because the alternate is that I can put this in warrant status. And I don't want to do that unless I necessarily have to. So at that point in time, you can be able to have your day in court to say whatever you want to say at that point in time.
Okay.
Okay. All right. So I'm going to, but I have to do a pre-trial because I don't have any dates right now. But I have your name down, but that will give you the opportunity. You will be able to talk to the jurors. You will have the opportunity to have testimony taken. I know you don't want counsel, but you can have the right to have counsel at that point in time. Would you like to have me assign counsel to you?
I need effective counsel at that.
Okay, I was gonna say, would you like to have counsel assigned to you?
Yes.
Okay, so I'll get some counsel assigned to you. So I'm gonna have you come back to make sure that that counsel is assigned to you. I am going to need some information from you, but not online. This is public to you. This is public to everybody, and I don't want them to have your business. Can you call
Okay.
the court this ends, ma'am?
Yes.
Okay, you ready to take down the number for me?
Yes, 1 second, please. I have to grab a pen.
Okay,
Okay, 1 second.
no problem.
Okay, I'm ready, ma'am.
313-965-9229.
965. Uh-huh.
93.
93.
We're just gonna need like your phone number and an email address, and then counsel will reach out to you. And you'll be able to talk to them, and then let me know. I'm gonna have you come back to court on 9/20/2022, just to make sure you have counsel in place. And then we'll try and see if I have any dates. I'm gonna ask them, can I have some dates for next year for jury trial, or this year if they have some. I would like to do them this year, but I'm gonna see what I can do, okay?
Okay.
8:30 a.m. I'm gonna set your bond at $0 personal. All that means is that you just come back on your own. No money is put down into place, okay? So
Okay.
I'm gonna call the courtroom so I can get that information, so I can send it over so that we can get you counsel assigned to you directly, okay? So that way you can handle this. You can have your day in court. You can say whatever you want to say within reason. You know, this is courthouse, so you haven't used any bad language or anything like that, and that's what I'm really referring to, okay? And you'll have your time and your day in court to dispute these matters, okay?
Okay, thank you.
You're very welcome. If there's nothing further, that concludes this hearing. You can go ahead and sign off, ma'am, okay?
Okay, have a good one.
You too, thank you. Don't forget to call.
Okay.
Okay, thank you. Now calling the matter of the people versus Cinnamon Woodford. This is ticket P1217275. Count 1, no plates on trailer. Count 2, no insurance misdemeanor. Count 3, drove while license suspended. Ticket number SP11022227. Count 1, no receipt of registration. Count 2, no proof of insurance. Appearances for the record, starting with counsel, please.
Good morning, Your Honor. Harry Bachman for the defendant. Ma'am, state your full name.
Cinnamon Woodford.
Good morning, Ms. Woodford. Your Honor, the defendant is continuing a not guilty. We're asking for a waiver trial date by way of Zoom, please.
All right, if that's correct, ma'am, can you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Ma'am, did you have an opportunity to talk to Attorney Bachman in private about your case and about your rights?
Yes, ma'am.
My understanding, you would like to have a bench trial. That's a trial before myself as the trier and finder of facts. Is that how you want to move forward, ma'am?
Yes, ma'am.
All right, I'm going to set it for the date of December the 5th. December the 5th, that's going to be at 9 a.m. It is going to be via Zoom. So the same way you zoomed in today, zoom in on December the 5th, 9 a.m., okay? Bond to be set at $0 personal. All right. There's nothing
Okay,
further,
thank
you're
you.
all set, okay?
Okay, thank you.
You're welcome, have a good day.
You too.
All right. Yes, okay, all right. Now calling the matter of the people versus Cinnamon Cheyenne Warford. This is ticket number P1217275. Count 1, no plates on trailer. Count 2, no insurance misdemeanor. Count 3, drove while license suspended. Also calling ticket number SP11022272. This is no proof of insurance. Count 1 of that same ticket is no receipt of registration. This is the date and time set for a bench trial in this matter. Appearances for the record, starting with Attorney Bachman, please.
Good morning, Harry Bachman for the defendant. Your name, please, ma'am.
Cinnamon Woodford.
Thank you, Ms. Woodford. These matters are set for trial. I do not believe there's been an officer who has checked in with the people being unprepared now at 11 a.m. approximately at the case is set for 9. We'd ask you to consider a motion to dismiss here without prejudice. Okay.
No officer having checked in on any of these matters, the court is going to grant your request. I'm going to dismiss these matters without prejudice. You're all set, Ms. Walker, okay?
Thank you.
You're welcome. Have a good rest of your day, okay?
They're going to sue you, and then they're going to attach a lien on absolutely everything that you own to satisfy the judgment they get against you. And they will take your house, they will take your car, they will take your bank account, they will attach to where if you ever want to start working and get a paycheck, they're going to garnish all that money. You have insurance, liability insurance, so that if you ever get into an accident. Good morning, Mr. Emmett. Do you have a lawyer today?
No, representing myself.
You were charged with unlawful carrying of a weapon. It looks like you also, out of the same charge, picked up a fraud as well. I mean, okay, you can represent yourself. It's your absolute right. That's, I don't know how smart it is. Have you ever represented yourself
Yeah,
before?
many times.
How did that go?
I have many dismissals.
For what kind of cases?
Had a dismissal on unlawful carry before.
And you represented yourself?
Yes.
In this court?
Harris County.
Oh, well, I found no probable cause. That's why I got dismissed. You didn't represent yourself.
I was representing myself, but the judge did find no probable cause.
I found, was it me?
No, it wasn't you. Well, I don't know. I think it was you.
I found no probable
I
cause.
think that was you.
You didn't represent yourself for nothing, man. I did it. No. Okay. So, well, you can hope and wish and dream, whatever. If you want to represent yourself, you're entitled to do that, right? But, you know, well, I like to tell people it's brain surgery. When you need brain surgery, when you need heart surgery, are you going to do that on yourself? Because you're not trained, you know, you don't know how to perform open heart surgery. Same thing with the law. You know, you're not trained in it. I'm assuming that you didn't go to law school, did you? How far did you get in school?
I graduated school. I went to some college.
How far did you get?
2 years I got certificates. Not in college, but I went to school.
Okay. So we're in the middle of trial now. And so I don't have the time to go through all of what they're called Faretta warnings to see whether you should represent yourself. I'm happy to do that. Why don't we delay it off a week? Are you working at this time?
Yeah, and I stay in Austin. I don't live in Houston, so
What do you do for a living?
I have my own business.
Doing what?
Resell clothing, audio production.
How much money do you make a month?
I can't tell you, but it pays the bills.
You're very cryptic in all of your answers. And not only that, but you going to Austin, if you represent yourself, you're going to have to meet with the DAs on a constant basis to get evidence. So that's going to require you to come here to Houston quite a bit.
I was ready to find my motion today if I needed to be.
Okay. Before I do that, though, I need to have a Faretta hearing. If you're willing to wait, we can do that a little bit later when I take a break in trial.
I had my other case upstairs the same day. The judge from when I came to my
Have you
last
been up there
hearing.
yet?
No, I haven't been up there
Okay.
yet.
So go up there. When you're done, come back down here. Don't forget to come back. If you don't come back, I'm going to issue a warrant. Go take care of yourself upstairs and come back.
One eternity later.
Are you ready?
Yes, sir.
All right. So today is September 11th, 2024. It's approximately 12:25 p.m. We are now in court 5. In front of me, I have Eaton Emitum, case number 2522688. Would you please identify yourself for purpose of the record?
If a man eats on Amazon,
Would you please raise your right hand? Do you solemnly swear to tell the truth, and nothing but the truth, so help you God? That you're going to tell the truth. That's it. Yes? Okay. State, would you identify? Okay. So the reason that we're putting this on the record now is Mr. Emitum has been charged with the offense of unlawful carrying of a weapon. The case is 40 days old. It appears that probable cause has already been found. I don't know if I did probable cause on this, or if I don't know if another judge did, because I don't remember Mr. Emitum, and I was out a week.
it was another judge.
Yeah, lollygagging. So let's just do it for.
On August 2nd, 2024, officers observed a car without a front license plate, change lanes without a signal, and have expired registration as of March 2023. Upon approaching, officers smelled marijuana. PC search returned 4.17 grams and a loaded Smith & Wesson handgun. Additionally, there was a backpack with 3 checks that did not belong to him. Officer called Kumamoto, who said the checks were stolen from her restaurant on July 8th. when defendant broke the front window, went to the back where the checks were kept in the office, broke the hinge of the back door and exited.
So as a result, because of that, he was charged with felony fraud on that one, on the check. Okay. Yes, he has an open case in the 182nd. Looks like he made a $15,000 bond. With us, I am going to find there's probable cause to go forward. Well, hold on a second. We'll get there. I'll let you say peace, but do you have a Texas driver license?
I have a U.S. private property number with the FMCSA. With my vehicle was on there. It was sticker tags, everything for my business, the Amazon Estates. That's with the Department of Transportation.
Is that from the state of Texas or from where?
This is federal. This is with the Department of Transportation.
Okay, but you still need a Texas driver license and you need registration and
I did all my stuff with them because of private property that I had. They said I didn't, if I didn't need to get registration with the state of Texas because I registered. Yeah. They said that would be my voluntary, but since it's private property, I wouldn't have to register it.
Okay. From what I know of the law, you need a Texas driver license to be able to drive.
This is what's this case being tried on? That's what I'm trying to, because I'm kind of don't know what it's being tried on.
It's
Criminal,
yeah. Right. In jail time, right?
I believe so.
Weren't you taken to jail?
Yeah.
So that wouldn't lead you to believe it's criminal, right?
Yeah, but under common law, or is it military and tribunal? Because also with
I've been waiting for something like this for so long. This is so much fun.
I'm just trying to see what I'm being tried on, because what I was told with the U.S. side, I have to register with the state of Texas with the registration or licensing. I do have my own place with that vehicle too as well. So
you need a license to drive, a Texas driver license. That's it. You either have one or you don't. The federal government has regulated to the states through the Constitution that they have allowed the states on their own initiative to create laws regarding driving on highways and byways. So that's why you see every single state has different requirements for licensing, insurance, mode of transportation. The federal government has somewhat to do with it, but by and large, they have delegated to the states that they are their own entity with regard to creating laws in their specific highways. So that's why every single state has a different type of license, different type of insurance. Like the Texas driver license is white versus Arkansas might be yellow or red, or Hawaii might be. So that's every single state has their own laws with regard. In Texas, you have to have a Texas driver license. You also have to have liability insurance as a minimum in the event that you get into an accident. Those are the two main requirements that you need to drive. If you're going to drive a vehicle, it also has to be registered so that they know that you're driving the vehicle and that you own it or have the right to have that, so it's not a stolen vehicle.
I own the vehicle and everything. When I was here the last hearing with the judge, like what he was saying, he said that when it had applied to me, but he was going to see what they were going to say about the other court, about the probable cause of stopping me, because he said registration when it had in the front license plate, when it had applied to me.
It does apply. It applies to everybody. Everybody has to have a back license plate. They also have to have a front license plate. And so much, they also tell you where it has to be on the car. They regulate. You can't put it in the windshield.
State, right?
State.
Yeah.
Right. They tell you where it has to be. You can't put it on the windshield. You can't put it on, like on what's it called? On the light. It's got to be right there. They even tell you how many centimeters it's supposed to be from the street to the actual place on the car. That's how bad the state of Texas micromanages all these things. They even tell you how many damn centimeters it's got to be on the car. So you have to have a front license plate. You got to have a license, got to have insurance. So if you don't have that, you can't drive. And that's it.
Yeah, I didn't tell him I was traveling. I wasn't arguing with him, but I was traveling. I wasn't making commerce. I used to do medical transportation. So I'm kind of aware with licensing, the registration and everything. That's why with my private vehicles, I did that with the U.S. DOT instead of the state. But I didn't know that was
correct. You need a license. It doesn't matter whether you're saying you're conveying, whether you're traveling, whether you're, driving. It's a privilege. It's not a right, right? There's a big difference between a privilege versus a right. You have the right to walk.
I have the right to travel, don't I?
Yeah, taking your happy-go-lucky feet. You want to travel? Take those 2 feet to travel, not in a car.
Just what the 14th Amendment was saying, like I have the right to travel.
You do. Yes, and you can walk your happy ass from one part to the other part. Not in a car, though. Not without a license and insurance.
Was on there from what I did this with the Department of Transportation. They said automobiles were on there, carrier, bicycles.
They're wrong. I'm just telling you now, they're wrong. Whoever told you that, whoever, where you got that, it's complete. Because imagine this, Mr. Emitom, and I've seen this before. Imagine that you get into an accident, right? And you kill a 5-year-old kid. What's going to happen at that point? Whoever owns that car, the other people, they're going to come after you. They're not going to go after they're going to come after you. The first thing they're going to do is, do you have insurance? And if you don't have insurance, they're going to sue you. And then they're going to attach a lien on absolutely everything that you own to satisfy the judgment they get against you. And they will take your house, they will take your car, they will take your bank account, they will attach to where if you ever want to start working and get a paycheck, they're going to garnish all that money. You have insurance, liability insurance, so that if you ever get into an accident, you don't mean to do it. You didn't mean the kid. It's not an imperposement. It was an accident. It's happened. You might be looking at your phone. You're looking at, this pretty girl that's walking across the street, and then boom, you have insurance so that if that happens, the insurance company will pay on your behalf so you don't have to pay out of your own pocket. And they will even give you a lawyer to represent you on your behalf because that's what you pay for when you get insurance. If you get into an accident, lawyers usually call you and say, hey, man, tell me what happened. Was it your fault? Or was it the other people's fault? Because we want to know who to pay. And that's why for $30 to $40 a month, you get insurance for that very purpose. And I've seen people come here, they have killed someone, and they get a $250,000 judgment against them. I've seen it. And God, you'll never dig yourself out of that. So the conveying, the this, that, you need a license. You've got to have insurance. And we do it with every single person that comes in.
Can I say for the unlawful carry, the possession of marijuana, the person that was in the vehicle told the officer it was legal hemp that they got from the store. They have receipts and everything in Texas. You can have legal hemp. They got it from the store. Even told the officer it was theirs. He pulled me out the car. He didn't ask for any paperwork.
Now you're making the apples right. Now we got to test it. Is it weed?
Oh yeah,
is it hemp? Understand that takes time, but you also need a lawyer to represent you.
I found my own discovery. I was representing myself pro se.
And you can do that if you want.
Yeah.
But we have to go through a series of questions.
I represented myself plenty of times. I had dismissals here from
and for purposes of the record, so Mr. Emitom had a case with me here. It was actually June 7th of 2022. He was charged with another gun case, and that was with Victoriano. God, that was a TA too. And I found no probable cause in that case, right? So you didn't represent yourself in that case. I found no probable cause and they dismissed it. They didn't have to dismiss it, but they did dismiss it. So other than that case, have you ever represented yourself?
Yeah, many times. I have dismissals all through different Harris County. Traffic violations.
You're welcome to do it, who's one of the worst, who's one of the best presidents that in history that you think about right now?
To me, right now.
You can't think of one good president that we've ever had?
I don't know any.
Abraham Lincoln, he wasn't good?
I never met him. I don't know about him at that time.
Abraham Lincoln said something. He goes, you know what? He who represents himself has a fool for a client. That's what he said. Meaning that when you represent yourself, there is an inherent conflict and there's an inherent bias, and you may not be able to see things objectively. Meaning that you have your heart, you've got your soul into this case. So you may not be able to see from an outside position if they're saying something that makes sense. You're absolutely entitled to represent yourself. And if you want to do that, you're more than welcome to it. And I have no problem with you doing it. You need to understand, though, if you represent yourself, you can't come at a later day and say, you know what? I had ineffective assistance of counsel. My lawyer sucked. Well, you represented yourself. You now can't complain about that. You know, if you go to, you lose and I end up putting your butt in jail for a year, you can't complain. You're stuck like Chuck for a whole year because that's what you're facing. You're facing a year in jail and you got a bunch of other documents too that, you know, so.
My discovery from that last month that I
Well,
filed.
let's do that. What is your full name?
Eton, she's Roque Amaton.
Okay. How old are you?
I'm 34.
Where were you born?
In America.
Were you born here in Houston? Were you born in, okay. You read and write English, right? Okay. Do you have any learning disabilities or communication handicaps? Have you ever been declared mentally incompetent or treated for any mental health disorder? Okay. You said last time I asked you about your educational background, you graduated from high school.
Graduated high school, some college.
How far did you get in college?
About 2.5 years.
Did you do any legal courses whatsoever?
Left that and I started doing medical transportation. I was taking classes for paramedics. I was just doing my basics.
College.
I was just doing my basics. I ain't getting into it. Yeah.
Yeah, I mean, that makes sense. And when you're beginning, that's all you do anyways, right? Do you have any legal training, education, or experience?
Experience with dealing with court information before.
And any other legal? Do you know about the Code of Criminal Procedure?
Yeah, I'm familiar.
Do you know about the Texas Penal Code?
I'm familiar, but I'm not too familiar with a lot of statutes and codes.
Were you here for our earlier trial?
No, I went up.
I know you went to the felony court, but we were in trial earlier. Did you see what happened in trial earlier? Okay. What I'm trying to say is that the lawyers on both sides had to introduce evidence. There's a specific procedure that you follow to have evidence admitted. It's detailed in the codes. You have to know that because once you represent yourself, I'm going to treat you as if you were a lawyer. I will hold you to the same standard. And I'm not here to put you through law school because I have way too much drama as it is. I don't need any more drama, right? So if you don't do it the right way, I'm going to shut you down, right? I like to be nice to people, but I'm not taking you to school. Do you understand this? Do you understand the charges against you?
No, I don't understand the nature of it.
Okay, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail. What they're saying is that you unlawfully had a weapon. As a result, you were charged, and now you're facing up to a year. Do you understand?
Yeah, what they're telling me, but I still don't understand like why I went to jail for that. So that's why.
What do you not understand?
The court procedures or
No. I'm asking about the nature of charges. No, it's not. Don't talk about the procedures. Don't talk about the licensing, about the conveying.
Yeah, I know
No.
I'm getting charged for unlawful carry. And
Right. Do you understand that?
yeah, what's going on?
Okay. Do you have the right, or you understand the range of punishment that you're facing a year, correct?
That's what I've been told.
Okay. You have the right to court-appointed counsel. Do you want counsel to represent you?
I don't want legal advice. I don't need a legal team. I just want law.
If I offer you a lawyer now, would you want it? You really don't want a lawyer?
I represent myself. I could get none more by myself than anyone representing me.
Okay. Do you understand that you will not be able to claim ineffective assistance counsel if you lose at a later time, whether it's in trial, whether it's in a hearing, whether anything? Do you understand that? What that means is that you cannot appeal this thing. If you're found guilty and you go to jail, you know, a lot of lawyers or a lot of defendants like to claim, sorry guys, I'll be 2 minutes. A lot of lawyers, they're lawyers for screwing up. And they say, hey man, my lawyer messed up. I can tell you, like, that's the one thing that defendants complain about. And probably, I don't know this for sure, but I would suspect probably the number one reason why cases are overturned because of ineffective assistance of counsel, meaning that a lawyer, for one reason or other, messed up so bad that their cases have to be redone. You cannot complain about that at a later time.
I've seen that many times. That's why I'm representing myself.
But you can't, if you mess up, you cannot appeal this thing. Do you understand? Once, and if you are found guilty, that's it. Do you understand? You also have to comply with the same appellate procedures if you lose, meaning that if you want to appeal for one reason or the other, you have to understand the guidelines and the timing, and you have to comply with those rules as well. Do you understand? You will not be granted any special consideration because of your lack of formal training. Do you understand this? You may fail to properly raise points of error in the trial record if we go to trial, meaning that if we go to trial and you object to something, because you hear that a lot, right? This shouldn't be in there. You have to object properly. You can't just say object. There has to be more to it. You have to state the reason for the objection. It has to be a legal reason. You can't just say, I object, and expect me to hold something out. You have to give the legal reason. And there's a proper method that you have to state and ask me to do things for it to be recognized on appeal. And if you don't know this, you cannot at a later date complain. Well, I didn't know that. You understand? You still don't want a lawyer. I will give you a free lawyer. This voluntarily, knowingly, and intelligently made. No one's forcing you to do this. Okay. Knowing all this, are you sure that you still want to represent yourself? I got to tell you, I think that you look like a great guy. You look like you're upstanding. I have no problems that you represent yourself. Understand that you need to be careful what you tell them, though. Everything that you say, even if you think you're hurting yourself by admitting one thing or the other, you could be hindering your case, meaning hurting your case, even if you think you're helping yourself. Do you understand? I'll make you a deal. If at any time you want a lawyer, all you got to do is ask and I'll give you one. Really. If you ever feel like you're under the gun, that you feel like someone's taking advantage of you, I'm happy to give you a lawyer at any time. I want you to understand now, as a condition of your bond, though, I'm ordering you not to drive until you have a Texas driver license and a liability insurance. I'm ordering you not to drive. And I'm going to have you sign with me today an affidavit promising me you're not going to drive. If I find that you drive, I'm going to put you in jail. Do you understand?
I have personals.
Okay. You are not allowed to get into the driver's seat of a car and drive, convey, travel, however you want to term it. You cannot do that. And if I find that you do that, I'm going to put you in jail and I'm going to make your bond so high, your head's going to spontaneously combust. Do you understand?
That way from my right standing or
no, but I'm telling you that you can't drive, convey, get into the seat of a car. If you do, you're going to go to jail because I will revoke your bond. You understand? The only conditions I'm putting on you now are 3. No weapons, no picking up new cases, and don't get into the driver's seat of a car and drive, convey, travel. Are there any other adjectives that you can think of?
I'm sure there are, but
I guess I'll put et cetera so that it tries to cover any type of wording, so to speak. All right. So, Mr. Ematom, I'm going to find that you are okay to represent yourself. We need you to sign a form that you're going to do that.
even if I don't consent to any of these charges, because I do have my paperwork, I do have.
If you don't consent, just go. If you don't think we have jurisdiction, look, if I didn't think anyone had jurisdiction over me, do you think I would be here? If I was in your shoes? Hell no, man. If I didn't think that someone didn't have jurisdiction over me to be anywhere, I'm not going there. I'm not going to get out, take a shower, put my clothes on, because I like to be naked, right? You know, I'm not doing anything like that. So if you don't think we have it, just go. Otherwise, you're here. You know we do, right? Because if you...
I don't know. That's why I thought...
Let me ask you this. If you just took off now, what would happen? There you go. What does that warrant mean? What does it mean?
What do you mean as far as like the warrant?
As far as jurisdiction is concerned. Do you think that an officer is going to go out and actually pick someone up if they didn't think they had jurisdiction to do it? Do you know how much trouble they would get in? Do you know if Stephen went out there and arrested someone now just for shits and giggles, do you know how much trouble he would get in? Right? If he had no reason to do it, do you know how much trouble he would get in? Right? A lot. He'd lose his job. He'd probably get sued. Right? Can't claim immunity. He'd be toast, Swiss cheese. So that's what I'm saying. If you didn't really think that we didn't have jurisdiction, then go.
I had to take care of this matter because
you know we have jurisdiction.
No, because I was going to go to 515 Rusk and file my lawsuit, my civil lawsuit with the officer to arrest me because they did some unlawful, unconstitutional things that they did to me at that time. So I was going to take it there. You know, I didn't believe they had jurisdiction over me.
I would wait to see how this case goes first before you do that. You know, see how the case goes first before you start jumping the gun.
Like that's what I was waiting.
You know, but ultimately, you know, if I didn't think anyone had jurisdiction over me, I'm not going to go there, man. I have enough important things to do in my life as it is. I mean, you've been sitting here since 8:30 in the morning, where it's now nearly 1 o'clock. You know what I mean? Really. Let's get this thing done. That way you can move on with your life. We can move on with our life and just everybody be happy. That's what it's about. All we want to do is protect our city. That's all we want to do, you know, and I'm going to do it at all costs. That's it. All right. I'm going to have you sign this affidavit. After that, we'll get you out of here. And so, Mr. Emitam, you are going to have to make a plan to meet with Mr. Petrov here so that you guys can exchange evidence. He is our chief DA here, the evidence. He's the one that's going to present it to you. You can either do it here in court with us, or you can meet with them at their office, because you're going to have to get the evidence to look at it regardless. I'm happy to take any motions that you have now, and I can look at them, and then we can come back at a later date and I can roll on it for you. I see that you have a bunch of papers. I'm happy to take anything that you have and I'll take a look over it, you know.
The clerk, last month.
Do you see anything? Which clerk file it was?
I have it right here, the copy. It was with Marilyn Burgess.
Is that for us? Right? We would still get it then, right, or no? You filed it under this case number or the felony court case number?
No, I filed it for this one on August 9th. I have this case number on there, 2522688.
Yeah, that's it. I don't see anything. Oh, wait a second. I see a motion for discovery. Is that it? It's a motion for discovery?
Yes,
Is that the only one that you've done?
so far.
Okay. I have to talk to officers and back. You give me 5 minutes, let me take a look at it. And then I'm going to give you a copy so that you can look at it as well. Let me print it out. Pavel, get out for you if you want to just take a look at it real quick. No, I need him to swear to this, please.
Okay.
I just did the no driving affidavit. That's it. All right, come up, Mr. Emitam. Let's go back. Can we go back on the record?
Going back on the record.
All right, Mr. Emitam, I've gotten your motion. Have you read it?
Yes, Your Honor, I've read through it.
And
Your Honor, at this time, the state wouldn't even be able to comply with this order because it's asking for an immediate order of discovery. It sounds like spontaneously going to give
well, other than
the
that,
opposing party.
I mean, is he asked?
And it's not, the language is not aligned with criminal procedure or penal code. But beyond that, the only two pieces that are requested that are reasonable that I can produce with a timeline are 1 and 7.
Mr. Emitam, understand that you will get discovery, but sometimes it takes time. It's not immediate. It takes time to build a case, to get videos, 911 calls, reports from officers. It takes time. It's not immediate. In your motion, I guess it says he wants it immediate.
Immediate order.
There's just no way. We can't.
An inspection. Yeah.
But we will get it to you as he gets it, he will give it to you. I can grant you the order. I will take off the immediate provision, but I can grant you everything that you want. I'll give you their case file. I can give it to you when they get it.
Yes, but Judge, this discovery order is requesting things outside of the scope of discovery.
Well, I'm not going to give him the kitchen sink. I mean, like what?
Everything else. I mean, so 1 and 7 are aligned. 1 is requesting any documents, papers, books, accounts, letters, photographs, videos, which are body cam, objects or tangible things not privileged which constitute or contain evidence. Of course, I'm going to hand that over.
Okay.
2, any and all names of any witnesses, the Harris County Superior Court, State of Texas.
I mean, that's so broad, Mr.
And
Emmett.
or any political.
I mean, you want every
subdivisions.
single witness in Harris County? That's what that's asking for.
You have to properly represent myself for the case.
That's 4.2 million people. Really?
So that doesn't, it's
I mean, I'm not going to grant that. That's silly.
too
You want-
broad. It doesn't go into just.
I mean, imagine any and all names of any witness for the Harris County Superior Court, State of Texas, County of Harris, or any political subdivision thereof may have. That's so broad that to even try to comply with that would take years. I mean, in relation to this case, yes, nothing else matters. The only thing that matters is this case and nothing else. So I'm happy to comply with the names of witnesses in this particular case. Yes, I will do that. And I can mark on there for this case only. Are you okay with that?
Your Honor,
Yeah,
in the event that you were to grant something like that, it would need to be filed by the defendant. What you're granting is what is written. not what is subsequently modified.
Okay,
So-
I guess
The language just needs to
I'll
be
just,
correct.
okay, so I'm going to tell you is, you're right, Paul. I mean, right.
So I just wanted to clarify that for the
You're
record.
representing yourself. I can't do the work for you, right? He so kindly is reminding me that because I'm trying to, right. That's too broad.
We can go down the list if you wish, but.
Yeah, let's do it. I mean, we have.
So 3, a true and complete original or certified alleged contract with wet ink signatures between the petitioner, the Harris County Superior Court, State of Texas, and or political subdivisions thereof may have law states that in order for the Harris County, and he's not even citing law, valid lawful contract between the petitioner, let them bring it forward for petitioner's inspection or immediately dismiss all charges. I believe this is going into UCC. This is not,
I mean, here you're going into the sovereign citizen type language.
Just common law.
Okay.
Your Honor, I will not be agreeing to that.
Here, there's no, I mean, you're saying a true and complete original and or certified copy of the alleged, it's not even spelled correctly, contract with wet ink signatures between the petitioner and the Harris County Superior Court. I mean,
So I'm opposed to that.
what contract?
Contract, complaint, whatever. I know this is statutory and it's not going over common law, so I'm not familiar with the statutes like I explained before.
Well, you're a lawyer now. You're going to have to familiar yourself with it.
So try me on statutes. I want to be tried on common law.
You're going to have to do it. I'm not sure. There's no common law here. It's done by statute. There's no common law here. It's all done by statute. And since you're the lawyer, you need to know that.
I recognize the steps of the statutory steps. That's why I don't recognize.
So
being tried in
let
jurisdiction.
me ask you this. How on earth are you going to represent yourself if you don't even know that?
So I get everything I need in my discovery.
He's not, no. He's going to give you body cams. He's going to give you 911 call. He's going to give you witness lists. And that's it. Right? Is there anything else that would be in here?
Going down the list.
I would, there may be dash cam I need to check. So I haven't gotten the body cam or dash cam yet. I need to check what all this.
Mr. Emmett Tom, I mean, let's get real. If you're having problems with things of this very elementary nature, how are you going to represent yourself? I'm happy to give you a lawyer, but some things are just, I mean, there's no.
We must conclude this hearing with the remainder of the list as well, and then we can go with,
Hold on, just so he knows. So number 4, a true and complete original and or certified copies of the criminal record of the attorneys of record, judge, magistrate, pro tem, commissioners, witnesses, as well as all officers of this court. That doesn't apply here, really. I mean, my criminal history, you think I have criminal history?
Do I need to ask to go to a higher court or a higher court look at this matter, or?
I mean, you can do anything you want to in life until someone says no, right? But I don't know where you're going to get. I mean, appellate courts need jobs too. How far are you going to get? I don't know. How much money are you going to waste? I don't know. A true and complete certified copy of all oaths, commissions, as well as bonds of all officers of the court, including but not limited to deputies, court clerks, judges, magistrates, pro tems, commissioners that have or may decide to involve themselves in this matter, appointed or elected, signed under penalty for perjury on and for the official public record. Well, I don't know what bonds you're talking about. What bonds? Like James?
Bonds, bid bonds,
Which ones?
appearance bond, bid bonds.
I'm not familiar with that. Affiliation of any and all states, witnesses, and all officers of the court. So I can't.
state as opposed.
I mean, I really. Any evidence which in any way is exculpatory to the case? Yes.
Anything in state's possession, I'm unopposed to. I will produce anything exculpatory that's in our possession. But
Number 8, documented proof of claim of injury signed under penalties of perjury with all immunities waived from the judges of this court, attorneys of record, the Harris County Superior Court, State of Texas, County of Harris, as well as this court, and for the official record. Documented proof of claim of injury signed under penalties of perjury. So what are you referring to there? What?
Against me, whoever made the complaint against me, who's the opposing party.
Okay. Well, the Harris County District Attorney's Office.
They have to complain. I don't recognize who that is.
What do you mean you don't recognize?
to the state of Texas or Harris County's, what was that?
Right. So they alleged that you did something unlawful. As a result, the officer arrested you and then brought that information all to the Harris County District Attorney's Office. And then they, in a two-pronged matter, number one, I found probable cause in this case, and then a grand jury indicted you on your felony case. So it's the Harris County.
I haven't been indicted on that. I just came from upstairs. I haven't been indicted on that case yet.
Has it been indicted or no? Well, I mean, they have, I think, up to 180 days to indict you, but, okay. I mean, I guess, would it be the information is that he's asking for? But you want the charging instrument, I guess, is what you want.
Your Honor, again, I think it's just
I know that
a
it's,
textual misunderstanding. But if it were rephrased correctly, I can better understand what is being asked. And therefore, that's why I cannot agree to this order, because
I get it, but I'm trying to go through it with him so that he understands.
if it
what he's
aligns
asking.
with if it aligns with something I can understand, sure. I mean, I can understand what's being asked and then I can turn it over, but I don't have that. This is not that.
Yeah, there's a lot of stuff here, you know, I'm,
Yeah, I don't know what's not being understood mostly. Like,
here, let's go through number 13, just because there's a lot here that you got 16 and it's already 130. The COERCED number tied to this case, which will show that this court and or officers of the court are profiting off this case, and it is trading on the stock market on and for the official public record.
I mean, I am the trustee for the name Eton Ematon. Birth certificate's right here. Administrator and the beneficiary for their name. I've been the trustee. I have my paperwork that I need to prove to the court.
And that may well be good for federal stuff, but not for us. This is state. A copy of all officers of the court registration report and profile, which is registered under Dunn and Bradstreet on and for the official public record. You're going to have to go through this motion more. It needs to be more specific.
Just for the record's purposes to say as opposed to this motion in its entirety at this point.
So not 1 and 7 then.
Not with immediate, not that language.
Oh, right.
And we cannot modify that.
So it needs to be more specific. And you need to have a more realistic guideline. They can't give you stuff immediate because he may not even have it in his possession. So I can't order him to give you something that he doesn't have in his possession.
How soon can they get my next court date? Will they have it, or how soon?
I don't even know.
Body cam and dash, I can escalate that by the next court date. The lab, I am unsure of a timeline at this time. The lab of the substance.
Okay. And I'm going to tell you now, it takes a lot. It takes quite a while to get labs done because, I mean, you imagine we live in a city with 4 million people. Do you know how many people get arrested with illegal substances that have to be tested? You get in line in front of everybody else.
I do have the lab results from the store that I got it from. I have the store that is in the lab result papers that they got it from in Houston. So I could submit that as well if it makes it quicker.
I mean,
I know you still have to do your own.
I know that you're saying that, but remember, there's always two sides to the story.
True.
So they need to test what they have to see what that is. And it's going to take a while, but it'll get done. You just be patient, but it'll get done.
At this point, we are pending body cam dash in the lab. That is what is pending.
Typically what we do is we'll set it out 30 days and then we'll just have you come back. And when you come back in 30 days, we'll see where they are. And then at that time, you guys can make a plan to go over the evidence. And I'm not going to give him a copy though. He's just going to have to review it.
I believe it's subject to inspection.
Right. So you're going to have to come bring a computer.
USB.
It's not through VHS. It's through.
I'm unaware. I'll familiarize myself more before the next court date of the transfer of.
You're going to probably need to bring yourself a computer that has a CD-ROM because usually they have stuff on CD-ROM drives or on CDs that you're going to have to be able to look at it. Any kind of dash cam, any kind of body cam, they usually put it on a CD-ROM or on a CD for you to be able to look at it. The only other thing I need you to do is I need you to swear to us that you're not going to drive. I am making it a condition of your bond.
I hold that until
I
put all the stuff in my paperwork. I don't drive. I don't go by driver's license. I have my passport that I do go by.
I need you to do it now. Okay. I need you to do it. And I'm making it a condition of your bond that you sign the document that you're not going to drive.
convey.
Contract of consent say anything or agreement say anything like that, because I'm still trying to see the.
I'm going to revoke your bond. If you don't sign it, I'm going to revoke your bond. That's it.
I gotta be forced to sign that. If I don't sign it, I can't have the option to take that
Oh,
paper.
no, I'm not, I don't have to sign it, but I'm going to revoke your bond. Sorry.
I don't understand.
Because I am ordering you as a condition of your bond not to drive, convey, travel, any way you want to put it, behind the wheel of a car in Harris County, Texas, unless you are properly licensed with a Texas driver license and liability insurance in your name.
So I go by my U.S. passport now. I don't go by my Texas driver license. I don't go by licensing.
Nevertheless, I'm having you sign a document that you understand and that you promise that you're not going to do it.
I don't understand it fully, but that's why.
If you don't, that's okay, but I am going to revoke your bond. And that's it. Correct. You don't have to sign it. You know the consequence. You're hearing it now. If you've never heard it before, you're hearing it now for the entirety of the case. If you get your driver's license and show me that you have.
I'm not a commercial driver. I don't engage in commerce. I don't do.
Do you think that the 5-year-old kid that gets hit and killed in a car, or the 69-year-old grandmother that ends up paralyzed from an accident, cares whether you were conveying, whether you were in commerce, non-commerce? Injuries don't care whether you're conveying, whether you're traveling. Accidents happen whether you're conveying, whether you're driving, whether you're traveling. That doesn't care, right? When you get into an accident, it doesn't matter in what method you're doing it. An accident is just that. And if you have an accident, I want to make sure that the other party will be taken care of. I'm only asking you to follow the law. I'm not asking you to split the atom here. Great. I'm asking you to sign this. If you don't have to, but I'm going to revoke your bond. That's it. And Mr. Emeton, if you get a Texas driver's license and you get insurance, I won't take this deal off.
That's what I believe in, and that's believe the Constitution. I don't. Was it?
That's okay.
They trying to apply that I need to get a license and insurance when I used to be a commercial driver for the state. I don't commercial drive anymore. I don't do medical transportation. I'm just a.
Did you hear what I said about an accident, about whether you're
I
conveying or
understand
traveling?
exactly what you mean about the accident.
Okay.
I know if I was to get on the accident road with no insurance, I could get sued and it'll be a civil matter and I go to jail. I understand that. That's why I travel very cautious. I don't.
You just said I drive. You said the magic words.
I was a driver.
Come on. Don't be Helen Keller. Come on. And I'm trying to protect all of Harris County.
I'm not
You're protecting you. I'm protecting all the 4.2 million people here. That's what I'm doing. Because if you get into an accident, I know that you're not going to be out a dime out of your pocket. But all those other people, they're going to be out a crap load of money. And I'm going to do everything in my power to protect every single person of Harris County. And I don't care if I offend you. I don't care if I make you mad. I don't care if your sensibilities are upset. Don't care. I don't. All I want is every person protected. And that's it. And I'm doing what the law requires. I'm not asking you to do anything that's not outside the law. And you, as a lawyer, should be able to look it up and see, because it's all in the transportation code. So you can sign it. If you don't, I'll have you meet with Stephen. That's it. They're reserved.
I'm waiving my right to the court.
No.
Signing that's waiving my rights. It's a contract. It's me.
What are you waiving?
My right to travel. That's infringing my right to travel with the Constitution.
No,
I wanna protect
no,
my rights and-
to dodge patas.
I don't know what that means.
Happy trails. Use your feet. You can travel with your feet.
I can't. I live in Austin. I don't live here in Houston.
Take a bus, take an Uber. But I want to make sure if you're caught driving, I'm going to put you in jail and I'm going to make your bond so high you will spontaneously combust, because I want you to understand that I mean business and I'm protecting every single person I can. And that's it.
The court forced me to sign this right now.
No,
I mean, with jail or arrest if I don't sign this. Right
correct.
now.
That is correct. That's correct.
Imprisonment if I don't sign this. This is on the record.
It's on a record. I have a reporter right here and it's on video. Can you file the bond conditions as well? No driving without a license, please.
This is it right here.
That, and I'm going to have them file it just in so I can give you a copy as well.
R 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me.
Mhm.
There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
Deputy Laura, do you know if he's been served with the indictment yet?
I'm not sure.
All right, thank you. So we're back on the record in 2024 CR 2974, State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness. You need surgery and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right. Norma, get someone from manage to sign counsel here, please. All right. Just have a seat and we're going to have an attorney come down.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right, so let record of the court show that I, Hector Casanova
Just one
Jr.
second.
The
We're,
accused
just
in
one
the-
stop.
Yes, sorry.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action.
All right, and
Furthermore,
let me
let the
stop you.
record also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment, and the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from managed assigned counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself to my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under. Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
All right, I'm going
admiralty or military
to counsel.
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for managed assigned counsel, period. That's it. So have a seat. Managed assigned counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat. Thank you. Yes.
We have talked. I've informed him that I'm here, to help him in whatever he needs help with. He's going to consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay. All right. And so you'll be appointed as standby
Yes.
counsel then.
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So.
All right. We're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right. So, Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right. And he informed me you wanted to place something on the record?
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right. Who threatened or coerced you to come to court?
The county of Texas.
How so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date, and you can accept the state's offer, come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date, and then you'll sign it. Mr. Bach will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome, and thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator, and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
All right, I think that's our last case for the day. Is that correct? All right, thank you for coming over, Mr. Bach.
Yes, Judge.
On the record, court is calling 2023 CR 9473, State of Texas versus Joe Edward Serta. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Brandon Lopez for Mr. Serta.
Are you Mr. Serta?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
We have, Your Honor, and yes.
Court will find that the state is in compliance with discovery. Mr. Serta, showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Serta, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of driving while intoxicated, third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Good. No.
Did you intend to give up those rights and enter into a plea bargain agreement?
Oh, yeah.
That's okay. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do, Judge.
Do you believe he is currently competent and was legally sane at the time of the offense?
In my opinion, he is, and he was, Your Honor.
Mr. Serta, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, I am, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $500 fine and the state opposes your application. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that if the court were to grant your application, that there be a TAP evaluation, 200 hours of community service restitution, 2-year driver license suspension, VIP panel, DWI intervention, 10 days in the Bexar County Jail as a condition, regular UAs and sober support meetings. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection.
All right, Mr. Serta, it's going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, if you all can't whisper, then you can't talk. We're on the record. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Ms. Ferguson, when can we bring this back towards the end of January?
You want to do the first, February 1st? Or we can do the 25th.
Let's do the 25th. All right, you're going to come back on the 25th. On the 25th, since there were no objections, I'm going to make a decision on your application based upon any other evidence that's presented to me, and also based upon the TAP evaluation in the criminal history, which will be the evidence that's part of the evidence that's presented. Do you understand?
Yes, Your Honor.
All right. Do you have any questions about anything?
No, Your Honor.
All right. Anything else from either side?
Nothing further, Your Honor.
All right. Once you sign the reset form, you are excused.
Thank you, Your Honor.